Hello, welcome to King's Advocate Network, where we discuss the society and the law. I'm your host, Kingsley, and in today's video, we shall be discussing the natural law theory. However, in my previous video, Introduction to Legal Method, we covered everything that has to do with the meaning of law. So if you are a beginner in the field of law and you have not watched that video, I encourage you to go and check out that video, because that video will help you in a long way to be able to appreciate everything we are going to say today concerning the theories of law. Of course, you cannot talk about the theories of law without knowing the meaning of law. So I encourage you to go and check out that video. If you are a beginner, click the link above to go and watch that video, or you can wait after watching this video, you go through that video. That will go a long way in order to shape you properly on the understanding of law. So today we are facing natural law. So what we are going to do in this video is that we are going to first and foremost understand what natural law means. Then we go to the historical perspective that surrounds natural law, as well as the authorities that are there. So I encourage you to get ready, get your jotter ready, because we are going to take down some relevant points that could help you. And you cannot write your first semester exams, or if you are a person who wish to have the knowledge of law, you cannot talk about natural law without calling some certain names, without mentioning some certain authorities in the field that describes what natural law means. And natural law is just an angle that tries to explain the meaning of law. There are various schools of thought. There are various theories of law. All of them is trying to describe law in their own perspective. So we are going to consider the perspective of natural law school of law today to see what they say that law actually means. So in your elementary understanding, what do you think is natural law? Basically, natural law reduced to its simplest meaning is simply a legal concept or philosophical concept that says or posits that certain rights and moral principles are inherent to human nature and can be dictated or discerned through reason. According to this theory, these principles are universal, unchanging, and exist independently of any human-made law or government decrees. So what I want you to take away is that natural law, in its simplest understanding, believes on the assumption there are certain principles in every man. There are certain elements of morality in every man that prompts him to do what is good and to abstain what is evil. So natural law is just based, of course, you know that all the theories of law are basically based on assumption. Assumption in the sense that all of them sees law in their own perspective, and you cannot say that any theory is 100% right and the other theory is 100% incorrect. All of them are right in their own perspective. So natural law is saying that law is not that which is written on any other book. Law is not this which is written in the Constitution. Neither law is any other thing that is contained in statute. Law is that which is written all over us, which is written within us, which is written in our consciousness. As a person, you have the consciousness to know that if I slap my friend will not feel good. As a person, you have the consciousness to know that if my child is hungry, I'm supposed to give him or her food. As a person, if your mother is sick, you have the consciousness to take care of her because you believe that is your mother. That is what natural law is saying. It's saying that though there is no law mandating you to take care of your child, though there is no law mandating you to take care of your family, though there is no law mandating you to respect your teachers, though there is no law mandating you to maintain a good relationship with your friend, but within you, you know what you are going to do in order to make that, sustain that relationship. That is what natural law is saying. So when we are talking about natural law, don't see it as something that is very big. It's not big. Natural law is just a principle that is saying that irrespective of what is contained anywhere, the law is within us. That is to say, every person has that inherent right, inherent knowledge of what is good and what is bad. And the philosophers of natural law, because we are still going to consider the philosopher of natural law, don't worry, we are starting with the proper understanding so we can proceed to see the philosopher behind natural law. So the philosopher behind natural law is simply saying that law, we should not go elsewhere to look for law. We should not go to Cameroon to look for law. Neither should we go to Beijing to search for law. That law is within us. We don't have to consider statute to know what the law says. That law is within us. Every person has intellect that tells him that this is right and this is wrong. So, but there are, when we shall get to the criticism of this theory, we shall expose more that contradicts what these people are saying. But this theory is basically saying that every person knows what is right and knows what is wrong. And so to some extent that is true, because every person know basically before committing any crime, you know definitely, apart from the law, you know that killing somebody is not good. You know that taking the life of somebody is bad. Both is a natural knowledge. All of us know, because you can't, if that to take your own life, you will not like it. So why will you take the life of another person? If you just stand up now, and give me a dirty slap, that dirty one, I mean brown slap, I will feel bad. You too, you will regret it. If you are a person that have consciousness, you will regret it and see, like, especially when I didn't retire it, maybe you just give me and I just felt calm, like you will be troubled. That is what the natural law is saying, that every person has intellect within him or her that tells him that what to do and what not to do, and that automatically becomes natural law. So let us go back to our definition and explain some certain elements that are unique to natural law. Number one of the elements unique to natural law is universality. So by universality, we say that natural law principles applies to all people, regardless of culture, regardless of time, regardless of period. Like now, for instance, this issue of murder. Killing somebody in all parts of the world is not only a crime, but against their morality. The Christianity prohibits killing, the Muslim prohibits killing. In fact, most of them will argue that Muslim law doesn't support, Muslim as a religion doesn't support killing. Muslim, even under their law, it is a homicide. It is if you kill somebody, you are punishable under the Sharia law. So Muslim doesn't permit killing. It's just a erroneous assumption that is imposed on Muslim to say that they are Muslim. No Muslim of the world, no religions of the world permit killing. The Buddhist doesn't permit killing. The Hinduism doesn't permit. African tradition, none of them permit killing. Although during the old days, there was a kind of sacrifice that was made to the gods then. But that was not an authorized killing. It was basically done in order to appease the god in some exceptional circumstances. And most often they were doing it out of ignorance. But in these Middle Ages, there is no religion in the world that permits killing. So that is what natural law is saying, that is universal in application. The law that prohibits killing is universal because it's universal. That is what natural law is. That is what natural law is saying, that it is universal in application. That law is not that which is contained anywhere in statute, but is universal. Number two element in the definitions of natural law is that it embodies the principle of morality. It has to do with the moral basis. So by moral basis, we mean that natural laws are rooted in morality and ethics, suggesting what is right or just, and can be determined through reason and intrinsic nature of humanity. Do you understand that? So we are saying that natural law flows from principles of morality. So natural law most often, in fact, natural law is rooted on morality. It's simply saying that which is written in your conscience, thou shalt not do to any other person what you don't want them to do to you, is a cardinal principle. Apart from the fact that it's stipulated in the Bible, it is stipulated in almost all the religions of the world. No religion permits you to do to your neighbor what you don't want them to do to you. So that is what natural law is saying. Natural law is basically rooted in morality. If you know that you slap me, if you slap me, I will not feel good. Why should I slap you? If I know that if I steal your money, you will not feel good, why should you steal my money? That's what natural law is saying. Anything that you know that if I'm to do it to you will not be good, you will not feel good, don't do it to me as well. It's a principle of natural law. That is what natural law is deeply rooted on morality. In fact, morality is natural law. And of course, you know that law and morality are different things altogether. We shall go to the other positive to talk about that. But for the natural law has to do with morality. And that's why Thomas Aquinas said, when we shall consider them, they are among the chief proponents of natural law. Thomas Aquinas said that less injustice and unless else. And unjust law is not law at all. For Thomas Aquinas, if you disobey the law, if any law that is made that is antithetical or inimical to the societal growth, that law should not be respected. That is what Thomas Aquinas is saying in his own view. So the natural law is of the view that if any law doesn't speak to reason, if any law doesn't speak to natural justice, if any law doesn't speak to common sense, it should be disobeyed. So morality is natural law and natural law is morality. That is what we are just trying to say. Then another element in the definitions of natural law is that it embodies inherent rights. So natural law holds that all human individuals possess certain inalienable rights, such as the right to life, liberty, and property. So it is through natural law that drives almost all the fundamental rights that are enshrined in the world constitution today. So natural right is the mother of fundamental rights. It is through the natural right that we drive the principle of right not to kill, which is contained in section 33 of the 1999 Constitution. It is also through the natural right that will drive the right to fair hearing, which is contained in section 36 of the 1999 Constitution. It is also through the natural right that will drive the natural justice of nemo juris in contra sua, which applies in all the common law jurisdictions of the world. It is also through the natural right that will drive the route to natural justice, audi alteram partem, here from both sides, which applies in all the common law jurisdictions of the world. It is also through the natural right that we get the Bills of Rights, the African Charter, the European Union's law. It is also through the natural right that we drive all the universal human right that is guaranteed under United Nations charters on human rights. So these are the various cardinal principles. That is to say that natural law remains the source of the modern law. So natural law embodies human rights, natural law supports human rights, and natural law becomes the fulcrum upon which all the rights and constitutional rights guaranteed emanated from. Do you understand? I hope you are following this video. We are starting with the definitions of natural law. We break it down. Then we go to the historical perspective of natural law, where I will tell you the various proponents. And then we proceed to the criticism and the advantage attached to this natural law. And please, before we proceed, if you are finding this video helpful, don't forget to subscribe to this channel, because when you subscribe to this channel, you will be able to receive notification whenever a video that is important like this is posted here. And every day we post a video like this that has to explain law in a clear terms. So if I encourage you to hit that subscribe button, and not only doing that, when you do that, make sure you turn the notification button to all notifications, so that whenever a video like this is posted, you will be receive the notification on your phone, on your desktop, or wherever you are watching it, so that you'll be able to follow that video up. Remember, we help each other to grow, and the only way you grow in your study is to read ahead and to have the knowledge at your disposal. So we continue with the features in the definition we just pointed out concerning natural law. Then the fourth element on our list is that natural law influences all legal systems. So many legal systems, including those influenced by the Western thought, have been shaped by the principles of natural law, often uses this as a basis for human rights and justice. Like I pointed out earlier, natural law is the mother of all constitution. Natural law is the mother of rule of law. Natural law is the cardinal principles of justice. Natural law is the father and the mother and the sister and the uncle and the cousin of all the law we have in our society today. So that's why I want you to understand. What we mean here is that all other law is taking its advantage. In fact, the natural law theories argues that natural law is the basis to justify the validity of any law, but the positive is objecting this, because the positive holds that law is that which is enacted, and also Kelsen theories of ground law, we say that law emanates from the valid legal order. So they are going against that principle of natural law, which say that all the other laws should be invalidated or validated on the basis of natural law. So now we proceed to historical perspective surrounding the natural law. So the leading exponent of this natural law of jurisprudence or school of thought are the following. We have Plato, we have Aristotle, we have St. Thomas Aquinas, we have John Locke, we have Zeno, we have Marcus Cicero, we have Thomas Hobbes, we have Jean, we have Lord Patrick Devin, etc. Those who are the proponents of natural law theories. They are so enormous. So, but all of them has one thing in the common. Aristotle becomes the founding father of natural law. Natural law could be alluded to Aristotle. Aristotle is the founding father that lays the groundwork for natural law. He posits that natural law is that which is universal in application, whether it's received or not received. Almost all the common law countries, they all has their law received from the Britain, which is their founding colonial masters. But what Aristotle is saying in his own argument supporting natural law is that whether we receive natural law or we didn't receive it, it is a principle that are common to all jurisdictions of the world. It is a principle, it is a cardinal principle that does not have to be received for it to apply. For instance, the law prohibiting killing, like I pointed out in series of examples, is applicable to all countries of the world, not because it has been received. Even the France, which is not under the common law, or country under francophone country, or the francophone countries, they are not within the common law jurisdiction, but each of their law prohibits murder. So that is to tell you that there are reasons to natural law which says that it is a principle that are universal in application. Then we go to Marcus Cicero. Marcus Cicero is also another person that advanced the natural law theories. What does Marcus Cicero say that in his own view that natural law is? In most of his work, Cicero believed that natural law is universal, eternal, and unchangeable, applying to all people at all time. He famously stated that true law is right reasoning in agreement with nature. It is of universal application, unchanging and everlasting. It summons to duty by its commands and avert from wrongdoing by its prohibition. So do you understand what Marcus Cicero is also saying? All of them is still saying the same thing which you have analyzed in the beginning of this video, which is that natural law has a universal application and it is a law that agrees with reasoning of nature. So if the legislature enact any law that doesn't speak to reason, that doesn't speak to sense, that doesn't speak to morality, it should not be granted as law, less injustice nor less else. That is all they are saying. That is the argument of natural law, that natural law have to speak to reason, that natural law have to go with morality, that natural law have to be with that which is in agreement with nature. So any law that is not agreement with nature is not deemed to be natural law, and that should not be accepted as law for the naturalist. So this is just an extract gotten from the Cicero's work, which tried to say that natural law is a widely accepted principle. Remember what we are discussing, these are the chief proponents of natural law, and everything we are saying is in alignment with their own idea of natural law. Cicero also aligned with his own father figure in the field of natural law, which is Aristotle, to say that natural law is inseparable from morality. Now we'll consider another also a middle 16th century writer on field of natural law, which is Thomas Aquinas, Saint Thomas Aquinas. So the most significant development of natural law theory in the medieval period came from Saint Thomas Aquinas, who synthesized Christian theology with that of Aristotelian philosophy. So in his book Summa Theologica, Aquinas asserted that natural law is part of God's eternal law, which governs the universe. Aquinas believed that humans, through their rational capacity, could discern the natural law and therefore the divine will. This belief underscored the idea that natural law is accessible through reason, and it provides a moral compass guiding human behavior. So we understand what we are saying here. All these schools of law, all these theories of law are just saying the same thing. So Aquinas said that all other laws has its origin in natural law, and every other law can be validated or validated based on the idea of natural law principle. One thing Aquinas also brought on the table is that Aquinas differentiated between human law and natural law. That is between man-made law and God-made law or natural law. Aquinas is saying that human law, man-made law can only stand if it is derived its validity from natural law. It can only stand if it speaks to natural law, because natural law is the fulcrum upon which other laws should be built. That is the old and another side of argument Aquinas brought to advance natural law. He didn't just went to agree with Aristotle as well as Cicero, but he went ahead to say that natural law is different from human law, and human law can only stand valid as far as it doesn't go against natural law. When his words asserted that every human law is just only insofar as it derives its validity from the natural law, or only if it accords its essence to natural law. But if at any point it defects from the natural law, it is no longer law but a perversion of law. So this means that natural law serves as a benchmark to measure justice or otherwise the man-made law. Natural law serves as a benchmark to measure justice, and that is true. Because Even come to think of it, in our society today, any law that is made by the legislature that doesn't speak to sense, that doesn't speak to that natural justice, of course, it will always, the citizens, the societies will always be agitating towards it. That is to say, there is still arguments to natural law which applies today, because all the legislators, insofar as they are making law, they are liberty to make law. The Constitution empower them. So under the 1999 Constitution, Section 4 empowered the legislature to make law for the peace and order of the good government of the Federation. So they are empowered to make law, but they always do that taking considerations of natural law, which is that they can't just make law that accept morality, that support immorality in the society. And that is why you have the issue of ongoing debate whether abortion should be legalized or not legalized. Those who supporting abortion are saying that abortion is a fundamental right of a woman, that a woman has the right to do with herself whatever he wants, whether it's to kill her baby, that is her constitutional right. Then the other people are saying that you cannot permit killing, that killing, whether in the womb or physically or outside, wherever, that killing is killing. Do you see what they are saying now? So where the other people are arguing on the basis of constitutional right, that's on the basis of positive right, then those who support this idea of not giving woman the right to have abortion, thereby claiming the right of a child who is unborn, also support this idea based on the basis of natural law. And that is the issue today. In 2013, and Same-Sex Marriage Act was in issue. Then subsequently, President Goodluck Jonathan enacted that very law in January 9th, I think, 2014, Same-Sex Marriage Act, which prohibits a marriage between a boy and a boy, or a girl and a girl. That is gay marriage, as we have it today. During that era of debate, majority of people supported that because on the basis of natural law. So I'm trying to tell you how natural law shapes our understanding today in our society. So this natural law you are seeing, though it's not physically written down anywhere, it has a major impact on our laws. It guides our law. It is the moral compass which guides our law. That is what I just want you to understand. Natural law is the moral compass which guides our law up till today. All the laws that are being made often have its value traced to natural law. So it's still a law that is active and sharp. We also cannot conclude on the proponent of natural law without talking about a contemporary theorist in this field, which is Jean-Jacques. So Jean-Jacques brought another idea which is very sacrosanct for the understanding of natural law. Remember how this thing, if you are watching this video as you are dealing with legal method or jurisprudence, this is very important, because you cannot basically just discuss natural law without examining the relevant authority in that field. So this thing I'm telling you, these are the contemporary writer, which if you are dealing with examination on this particular natural law, you have to mention these people and mention the how they contributed to the advancement. We started by seeing how Aristotle becomes the founding father. We started also consider another writer, Cicero. We consider Thomas Aquinas. We're also going to consider, there are plenty of them, but these are the notable people who brought a lot of achievement or advancement to the doctrine or schools of natural law. So you cannot talk about this without considering Jean-Jacques. Jean-Jacques brought another idea of social contract to natural law. When you will be treating human rights, you will see this idea of social contract. And also in the field of jurisprudence, you will see the idea of social contract. So Jean-Jacques introduced a more complex view of natural law in his work, The Social Contract. He contended that while natural law provides a foundation for human rights, individual must enter into a social contract to realize and protect these rights within a community. So what is Jean-Jacques saying here? Because he famously wrote that he's the person that has the quote that man is born free and everywhere he is in chain. So the paradox highlights the tension between natural freedom and the constraint of social law, suggesting that while natural law offers inherent rights, the structure of society shapes how these rights are exercised. So Jean-Jacques is trying to say, just listen to me, I want to tell you something that is very important. Jean-Jacques is trying to say that natural law, although natural law has given everybody the liberty to know what is right, what is fair, and what is just, that people under the social contract theory What is social contract theory? Social contract theory is the idea that people agree to give up some of their freedom and obey government in exchange for protection and order in the society. So in return, the government is supposed to protect their rights. If the government fails to do so, people have the right to change or remove it. So social contract theory now is trying to say that, because I'm trying to tell you that Jean-Jacques brought an idea of social contracts to natural law, to advance the theory of natural law. So I'm trying to explain what social contract means. Social contract theory is just saying that the government, this could be implied or expressly done. It's not something you can say. You may say, like, let me just continue with my explanation. This social contract tries to say that the people came together. That's why I say it could be implied. We may not have come together, so to say, but it is implied. When something is implied, even in contract, means that it is not expressly stated or done, but it is implied based on agreement that could be invisible or not invisible. So it means that we people gathered together and said, let us surrender. Everybody has right. Everybody has, in ordinary, all of us should be governing ourselves. There should be governor everywhere. Everybody should be president of his own. So the idea of president and governor of a particular nation is because we have agreed, we surrender our rights through our vote to elect one particular person who will govern us. All of us surrender our right to elect a particular president of a nation who will govern us. All of us surrender our right to elect a particular state governor who will govern us. We surrender everything and give to this particular man, or you govern us. Please take care of us. Then the man in return, or the president or the governor or the chairman in return, ought to do so with trust, to take care of us, to give us security, to give us light, to give us every human goodness we need. This is what we call social contract. We all surrender our God-given right to them. They ought to protect us. That is what Jean-Jacques brought. He brought this idea to the idea of natural law, saying that although we all have this right, that this right we all have, we have surrendered it to government. Then the government in turn will make law which will regulate that our natural right, which will regulate our individual right. Do we understand? Like I'm trying to say here that Jean-Jacques brought the idea of that while natural law provides a foundation for human rights, individual must enter into a social contract to realize and protect this right within a given community. So it is though that natural law has provided us with rights. It has provided us with that kind of inherent right. But then, because of that social contract theory, which has been brought to the idea of natural law, we then surrender all these rights so that the government can take this right we all have in order to exercise some other power, in order to impose some other restriction, so as to achieve a desired goal, to create a society that will be balanced to all of us. Because you know that where your right stops is where mine begins. If your right doesn't have limitation, it means that my own right will be freed. You have the right to sleep anyhow you like. You have the right to do anyhow you like. But in as much as you are stretching your hand, don't use it to pierce my own eyes. You have the right to use your head and sleep and raise your leg up while we are living in hostel. But make sure you are raising that. If your leg touch me, I will give you a dirty slap. That is what we are trying to say here. So we are just trying to say that in as much as you have the right to do whatever you like as a person, please mind my own right. Don't use your own right to be a busybody to me. Mind how you control your rights. I think reasonably and do what you ought to do. So that's what we are just saying. Where your own right stops is where mine begins. And not because you have your own right to sleep anyhow you like in hostel will make you to use your own leg and drop on my head. I will just use cutlass and cut some part of it and throw it away. So that is what we are just saying. That is what the idea we are saying, that natural law give us equal right, but the government, for idea of social contract is brought then, it means that the government takes some of this right, receive some of this right for the purpose of giving us a benefit that will be good to all in the society. So there you have it. On today's video, we have successfully discussed the natural law theories. But like I said in the beginning of this video, the video has not yet finished because we have not considered the criticisms to natural law theories. So I will see you next week on that video. However, I also want to let you know that this is not our first video. We have also considered a lot of videos that borders on introduction to legal system as well as that of legal legal method. So I encourage you to click the playlist above so that you'll be able to go through it and see so many other videos that could be helpful to your studies. I will see you in my next video next week.